you have a much better chance today, if you're a dad, of succeeding, of getting equal shared parenting or something close to it than you did even 5 years ago, certainly 10, 15, 20 years ago. A much better chance of getting it. There are societal assumptions about men and their ability to parent. And it is the job of lawyers acting for men to challenge those assumptions. I argue that best interests has to be interpreted in light of the social sciences. And that is what my firm is doing now in the cases that we currently have. It is pursuing justice. And I'm not talking justice in the narrow legal sense. I'm talking justice in terms of doing what is right and good to make this a better world.
Gene C. Colman has been practicing family law since 1979. He carries on his family law practice in Toronto with 4 other associates as the Gene C. Colman Family Law Centre. They devote their efforts to maintaining and enhancing parent-child relationships, as well as grandparent-grandchild relationships. Most of their parent clients seek equal shared parenting. Their cases include parental alienation issues, as well as complex property and support issues. As a law student in the 1970s, Gene was instrumental in the founding of the Canadian Journal of Family Law. To this day, he serves on the journal's advisory board. Gene has been a veteran, outspoken advocate for equal shared parenting, arguing for that concept before the House of Commons Justice Committee when it was considering amendments to the Divorce Act. He is a published legal author who has been favorably cited by the Supreme Court of Canada. He has made presentations to various media outlets and organizations where his opinions and insights have been sought out, perhaps due to his 40-plus years of fearless advocacy and extensive experience in family law. Gene holds degrees from the Hebrew University of Jerusalem and Osgoode Hall Law School. He tells me that he is blessed with 7 children and many grandchildren. For Gene, family is the center of his universe. Finally, he is an advisory fellow for the Canadian Association for Equality and a donor for many years to the Canadian Centre for Men and Families. Gene, it's a pleasure to have you on the show.
Thank you very much. Thank you.
So thank you for taking the time to chat with me today. I wanted to start by asking you how you became interested in men's issues and how you became interested in equal shared parenting in particular.
Sure. Thank you for the question. Well, we have to go back quite a few years. When I started my practice in family law, when I was called to the bar in April 1979, I did whatever family law matters came my way. And I was fortunate to have a client back in 84, 85 who wanted to have what we back then called joint custody. I want joint custody of my kids. I don't want my ex just to dictate everything. I want to be a part of my children's lives. I want to have a say. I want to have some decent time. So joint custody was a rather controversial subject back in the 80s. There were 2 Ontario Court of Appeal cases. One was called Baker, one was called Kruger. And they basically stood for the proposition that a court cannot order joint custody where one parent is opposed. So I said to my new client, I said, well, I'm certainly willing to take this on. Back then, of course, I didn't have the background in joint custody law that I do today. I said, I'll take it on. I'll do some more legal research, but we got a problem with Baker and Kruger. So if you really are serious about this, you've got to expect to lose a trial and win on appeal by advancing unique arguments. He said, go for it, go for it. Well, much to my surprise, we won a trial. And over his ex-spouse's objection, we achieved an order of joint custody where the wife did not agree. I expected the other side to appeal. Acting against me was a very prominent lawyer in Hamilton who is now a judge. And that case brought a lot of satisfaction. It sparked my interest in joint custody. And I started getting invited to speak to different places, different groups. They wanted to, the case was reported in the press. Not from anything I did. It just got there and people heard about it. And pre-internet, of course, 80s, pre-internet. And I got invited to speak. And one of the places where I got invited to speak is a group called FACT, F-A-C-T, known as, by the long term, Fathers Are Capable Too. What a great title. Fathers Are Capable Too. So I spoke about that case. They had me back. I spoke about other aspects of family law. I spoke support law, property law, whatever. And I spoke there maybe 7, 8, 9 times over the space of a few years. And I was teaching these guys the basics of family law as it would impact their lives. I say these guys, but women too. A lot of people brought their new partners and second spouses. But more than me teaching them, they taught me. And before and after the formal presentation, I got to talk to these guys and really gained a much better appreciation of what they were going through, the pain they were going through, the pain of being cut off from their kids. And I became an activist because of these guys. So if any of you, Brian Jenkins, Paul Ford, any of you out there that might be watching this presentation, I thank you, because you galvanized me. I learned about what guys are going through in the family law system in Ontario. And I think the same would apply to across Canada, even the United States, if not around the world. And then I had an idea. There's no national organization. There are various groups. There was FACT, and there are other groups all doing good work. And I had this idea, let's get everyone together under some sort of umbrella organization and gain more credibility in numbers, and we'll lobby the politicians. By that time already, the Women's Legal Education Action Fund, LEAF, was doing fantastic work, advocacy work for women's issues, particularly with domestic violence issues, and they were really doing very good work. And they had the voice, they had the attention of the Supreme Court of Canada, because when a family law issue went to the Supreme Court of Canada, invariably LEAF was granted intervenor status. And I felt guys should have that too. Let's give a men's perspective. Not as a battle with LEAF, but let's just give a perspective. When the Supreme Court of Canada is considering a policy issue, let them have the perspective of men. Of course, not just legal advocacy, but advocacy across the board. And of course, CAFE, Canadian Association for Equality, and the Canadian Centre for Men and Families, CCMF, did not exist at that time. And so I got together with a number of people, such as my colleague, Carrie Lindy, who is a prominent family law lawyer, acting for men largely in Vancouver, and with others, David Shackleton, person known to many of the people that might be watching this. And we formed ultimately an organization called the Canadian Equal Parenting Council. And we succeeded in getting together a lot of the groups, such as FACT and others, into a national organization. And I'm very proud to have been part of that organization. I was the first secretary-treasurer. We decided it wouldn't be a good idea to have a lawyer as president, and I was happy not to be the president. And so it's been one thing after another. You know, I'm a very big advocate, Warren, of a rebuttable presumption for equal shared parenting in the law. But I wasn't always. So there were two. There was one a seminal uh, email listserv called Equal Parents of Canada, EPOC, and I remember writing on EPOC in response to people arguing for it. There was I don't know if we used the words rebuttable presumption of equal share. I don't think we used the word equal share parenting in those days, joint custody. But I argued against a presumption. I said there should be no presumption. I said each case has to be on an individual best interest basis. But I listened to what people were writing back to the posts that I put up. And I got convinced. And of course, as people were writing about it so vehemently and felt so strongly, I thought I better reconsider my own views. And I started reading. I started reading the social sciences more and more. And I became convinced from the objective evidence that a rebuttable presumption for equal share parenting, is the terminology used now, was the way to go. And that's what I've been involved in. So, to sum up, I thank the guys, the advocates, the dads, the granddads, grandfathers, stepmoms, mothers that educated me. And all I'm doing now is just trying to pay it back in whatever way I can.
That's a fantastic story. Thank you, Gene. There's a few points I wanted to touch on that you just mentioned. One is the best interests of the child. That's a phrase that I think almost everyone has heard at some point, and it's used in the family law system. But I'm curious, what are the grounds for that statement, and what is it based on? Is it, when a judge is making a decision about custody, or I guess it used to be called access, are most judges in Canada in the family law system aware of the social science research, or is it just their own personal beliefs, or is it something else upon which they're basing their interpretation of the meaning of best interests?
That's a great question. Best interests of the child is in the eye of the beholder. Now, Ontario's Children's Law Reform Act has had a list for some years now, for many years. Divorce Act has not had a list until March 1st, 2021, like just a few weeks ago. But while all family law lawyers and judges recognized that the paramount consideration or the primary consideration, or sometimes the sole consideration, depending on which cases you look at, is the best interest of the child. The question is, how do you determine best interests? So there's been a lot of ink spilled and trees cut defining best interests of the child. The classic interpretation over the last at least 41 years, I say 41 years because I've been practicing family law as a lawyer for 41 years, is that on a case-by-case basis, we determine what is best for this particular child before the court. Well, one can say in response to that, well, that's very sensitive. You want to do what's best for this particular child. But how do you define what is best? Like, best how? You can say, well, if you had a primary, one could argue, if you have a primary parent and the child is primarily bonded with that parent, Therefore, the best interests of the child are to remain with the primary parent. And the other parent, normally the dad, will have every second weekend and maybe once during the week. And maybe a week or two in the summer. Now, for many years, that was reasonable, what we called reasonable access, because you define best interests in terms of the primary parent. It'll be no surprise to you, Warren, or the listeners, that's not necessarily the way most judges define best interests now. So the struggle right now with the amendments to the Federal Divorce Act came into effect, as I said, March 1, 2021, and with almost word for word amendments to Ontario's Children's Law Reform Act coming into effect the same date. And I suspect other provinces and territories that haven't brought in similar amendments will. Though I'm sorry, I'm not quite up to date at all on what the other provinces are doing now. I apologize. It's a lack of my knowledge. Now we have a list of best interest factors in the Divorce Act. And I think that is really a step forward, but it's the way the legislature has worded the amendments to the Divorce Act. It's not an exhaustive list. It says including, then it lists A through K or H or something, A through J. And so I argue that best interests has to be interpreted in light of the social sciences. And that is what my firm is doing now in the cases that we currently have. So we've got one motion I argued, it's on reserve. We've got another motion coming up next week, I think it's next week or the following week. And we are, in our written submissions to the court and also in our oral submissions, we're arguing best interests, all things being equal, is approximately equal time with both parents and a say in decision making. Now notice I said all things being equal, because in many cases, all things are not equal. And where they're not equal, I agree, you must adjust the parenting schedule and the parental decision making in order to meet this particular child's needs. But what the social science research tells us is that all things being equal, kids do best when the parenting time is approximately equal. It doesn't have to be exactly 50-50. There are issues of where people live and transportation and work schedules and school schedules, you name it. Not that it has to be 50-50 or nothing, but approximately equal. Make sure children are not limited in the relationship with either parent. That's the goal that we're trying to do. We're not the only lawyers doing it. I know there's two others, but there are more. And let's hope that the law develops in such a way that just like some judges under the unamended Divorce Act, the one that we've had for many years going back, perceived in the Divorce Act a rebuttable presumption of joint custody, as they called it. They weren't the majority. There were few and far between. There were few. So hopefully we will be able to convince judges, ultimately an appellate court, that you must interpret best interests of the child in accordance with the social science literature.
Thank you. That would definitely be a good step forward. I remember I heard about this issue, I don't know, maybe a year ago, that most family law judges are not versed in social science literature, and yet they're making very consequential decisions that affect people's lives for for the whole future. And that's quite surprising, because in other fields, you wouldn't expect an engineering firm to be making subjective decisions on the strength of building materials. They follow the science. But
They
when it comes to
I love that analogy. Thank you. We're going to use that.
yeah, and
I love that.
there's nothing more precious than the life of a child and the future
Follow
that
the
it's looking
science.
forward to.
Follow the science. follow the signs.
You can use that one later. So I want to just take it forward a little bit. So you've told me about your beginning. So between the establishment of your firm and today, can you tell me about a few common issues that you've seen in your family law practice? Like some of the challenges perhaps that particularly fathers are going through, but any parent really, when they enter those courts?
Well, I would say one of the most concerning trends that I saw in my legal career, largely prior to forming the Gene C. Colman Family Law Centre, is gender bias in the family courts, which implies negative assumptions, negative stereotypes about father and men. My formative years practicing family law, the law was rife with gender bias. And it was very hard to overcome it. You know, women were good for certain things and men were good for some things. I'll never forget the day, many years ago. It was in the Oshawa family court. This is before the Oshawa court transferred to its current location on Bond Street. It was on James Street, I think. It was in a converted warehouse. So this is a number of years I'm going back for those from the area that go to the Oshawa court. I remember it was in that old courthouse. And the client that I had, wonderful guy, real estate agent, had been to 5 or 6 lawyers previously. He wanted equal time. And every lawyer got rid of him because he kept insisting you go for equal time. They were trying to get him every second weekend. They said, you won't get more than every second weekend. He came to me. I said, oh, I'll give it a try. It's, you know, there's a lot of gender bias out there. It's really difficult to overcome it. I remember the first morning of the trial. The judge walks in and says to the lawyers, I remember the other lawyer, I won't give his name, but a very fine friend and colleague, friend to this day. He comes in. He says, well, counsel, I've read your opening statements, and I think it's really great the way men these days are stepping up to be parents. I think that's really wonderful. Thank you, God, for sending this judge. You should have seen the look on my colleague's face. This was a judge that wasn't going to be bound by gender bias and by stereotypes. We went through the first day of trial. I was going to start my cross-examination of mom at 10 a.m. of the second day of trial. And the other lawyer, Charlie, so Charlie comes in, he says, Gene, can we talk about this first? I said, well, we got to ask the judge if, you know, he may not like it, they're going to take time off the hearing. So we asked the judge, sent the message back to the judge. He said, sure, go ahead. And we spent the whole day negotiating, and my client walked out of there with about 55, 60% of the time on a negotiated deal. The judge's one comment really had a very salutary effect. But that, at the time, so it must have been the late 80s, early 90s. That was even then an outlier. That was an outlier. You know, and I wish to this day there were more judges that thought like that judge. So you never know. I mean, you can get a judge that even today that thinks more along gender stereotyped lines. Now, of course, the Divorce Act, the Children's Law Reform Act, they're written in totally gender neutral terms. And when you read most decisions, family court decisions, they're published, they tend these days not to speak in terms of gender stereotypes. So today you're not going to have a judge say anything like that judge said walking in. in the reported decision. And you're not going to have judges say, well, men can't feed babies. No one's going to say that. It's just not politically correct. But do some judges and some lawyers still think like that a man can't feed a baby? Well, you can't breastfeed. That's just a biological fact. But you can bottle feed. And a man can change a diaper. And a woman can teach a kid how to play baseball or ride a bike. We are not and should not be bound by gender roles and gender stereotypes. Some judges, by the way they approach the matters, I regret to say, are. Many are not. You have a much better chance today, if you're a dad, of succeeding, of getting equal shared parenting or something close to it than you did even 5 years ago, certainly 10, 15, 20 years ago. A much better chance of getting it. So I would say, if you go to see a lawyer, and the lawyer says, well, you'll get every second weekend, I think it's time to get another lawyer. I think it's time. I'm not soliciting people to come to me. Can't handle everyone that comes our way as it is. But I'm saying, if a lawyer tells you, no, every second weekend, that's pretty standard, well, that lawyer is not up with the times. So it's a big battle fighting this myth. There are societal assumptions about men and their ability to parent. And it is the job of lawyers acting for men to challenge those assumptions. And it's the job of lawyers acting for in same gender cases to battle assumptions about people that are in same gender relationships. They're all sorts of family relationships. Your gender, no matter what it is, should not make a difference. Children need their parents, and it's the job, in my view, of lawyers to maximize the chances that parents are not cut off. So if in this firm, if we have a client that wants to cut off the other parent, nor all things being equal, remember that, normally we won't act. We do have one case right now where we are arguing for no contact at all, which is the first time ever in my legal career I've done that. But it's because on the facts of that case, we believe this fellow is a physical danger to the infant. I won't get into the facts of that case. I'm saying so, but I'm saying generally speaking, we're good to our word here. We believe in contact with both parents. So we have a client that's hesitant with that. We'll do our best to dissuade the person, but if it comes to it, then we won't take on the case, or we'll get rid of the case, because children come first. The interests of children come first. There's a one book that we're talking about gender bias and myths and stereotypes that I would recommend to the viewers. And that is by Professor Sanford Braver. It was published in 2002. That's 19 years ago. Wow. It's called Divorced Dads, Shattering the Myths. I just checked on Amazon this morning. It's available. Used copies available very cheaply. It's about a 3-4 hour read, depending on your reading speed. It's not a very thick book, but it's jammed full of great information, great stories, great social science research, as it stood in 2001, 2002. Divorced Dads, Shattering the Myths by Professor Sanford Braver. I know that book for me was very important. I read it and I read it again. Oh my goodness, where was this guy all my life?
Well, thank you for that recommendation. I will put the link in the description to this video so viewers can go and purchase the book and read it. I was very encouraged by what you said a minute earlier, that the likelihood of a divorcing father to obtain equal shared parenting today is much higher than it was, let's say, 20 or 30 years
Oh yeah,
ago.
a lot higher than 20, 30 years ago.
Yeah. So that's good. So there has been progress.
There
And
has there has been progress, yes.
in your opinion, has there been progress in terms of family court judges being better versed on the social science research? Are they more informed today than they were when you began your practice?
I'm more informed today than when I began my practice. As I told you earlier, it took a little push from members of the Fathers Are Capable 2 group to galvanize me to do the proper research. Because it's subjective, of course. I'm meeting with guys, and these are guys in pain, and they're going to a support group like FACT because they're in pain. They need the help from their peers. But I can't go in front of a judge and say, "Well, I was at this FACT meeting last Tuesday night, and you should hear what the guys are going through." I'll be laughed out of court. But get the social science research together that talks about how children do better. Never, and there also is research about how parents do better. Both parents, not just the dad but the mom, when dads are fully engaged.
Right. I sometimes wonder where these assumptions come from, whether it's people's anecdotal personal experience or whether it's something in the media. If you go back to television and film in the 1940s and 50s and early 60s, I think there was this sort of image of the good father who's head of the household and um,
Don't forget breadwinner, the
bread
breadwinner.
breadwinner. And now we have to acknowledge those were very different times. It's difficult to compare that to now, 70 years later. But just to say that the stereotypes about fatherhood in general were more positive on most shows than they are from the 90s until today. I grew up basically during the 90s watching shows like The Simpsons and, the bumbling father, idiot, Homer Simpson stereotype. That's
Yeah.
one common example, but there's many others in sitcoms where you have a mother and father and the mother is, the real parent who's doing the actual beneficial work for the child. And then the father is kind of just hanging around the margins of the family trying not to screw things up. And I wonder if that's where people get some of their ideas.
So is that a question or is that the answer?
Well, I
Your,
mean, do you
your, your
share this?
question gave, Warren, your question gave the answer.
Yeah, I,
Your, que-
I, yeah,
your question gave the answer. That's what it is. You look at TV and movies in the 80s and the 90s, even the 2000s, even today. You've got those stereotypes. They are embedded in Western society. And so it's really hard. And judges and lawyers are watching the same things. It's even to this day, it's really hilarious. And I say that in inverted commas. Really hilarious if a guy takes a football or a basketball to the you-know-wheres. Oh, that's so funny. But you can't do that to the same location to a woman. That's violence. Of course, both is violence. Hitting someone in the genitals with a knee, with a fist, with a football, whatever. It's not funny. But out there, if it's to a guy, it's funny.
yes, I
I mean, we've
agree.
all laughed at that. Even I've laughed at that. And think, oh my goodness,
Yeah,
you know, that. It's all part of the stereotypes. And I like when in your question how you worded it. The mother's the real parent, and the father's just on the periphery trying hope. The mother trying to keep him from stop screwing up. Um, yeah, Sanford Braver in his book. Okay, I don't get a commission on the sale of the book, but I highly recommend it. He talks about this and the whole process of these stereotypes and how they come about. And I think he uses the example of the football or basketball to the genitals. Um, You got to fight against this sort of stuff, and an advocate has to realize that our society is permeated with these biases. Now, in the last number of years, there has been a positive realization that we don't discriminate against anybody on the grounds of gender. But I can tell you this, while we realize that, and you talk to any judge and would say, do you discriminate on the grounds of gender? The judge say, of course not. Of course not. The judge would be insulted that you even ask that question. Any judge today would be insulted to ask that question. They don't perceive themselves as that. But I can tell you this. To this day, when we are advocating in our firm on behalf of a father, it seems to me, and I hope I'm wrong, I hope some judges see this and call me up all enraged and explain to me why I'm wrong. But what I have perceived, and my colleagues and that my firm have perceived, that when you're representing a dad, you've got to show that he is super dad. When you're representing a mom, you don't have to show that she's super mom. You've got to show she's a normal mom.
I wonder that sorry.
Super dad.
Yes, and that's difficult because it kind of goes against in a way, it goes against the presumption of equality between men and women. You have to show that a man is above average as a parent, whereas a woman just has to be average to get the same level of outcome in the court.
And I am arguing that it is absolutely contrary to Canadian Charter of Rights and Freedoms that guarantees the equality of the genders. That you should have to prove that your client is a super parent, super dad. I think that virtually all judges will dispute what I'm saying. And some will say, Colman, he's that father's rights crazy, and just sort of write me off perhaps. But those judges that know me, that I've appeared before and I've argued cases, know that I do have some academic credentials, and I am sincere in my beliefs, and I'm not trying to be critical of the judiciary, but I recognize we live in this society with gender biases, with gender stereotypes that permeate our very being, and we are all subject to them. And why should we expect judges should be different? And they're not. So you have to make, as a lawyer and as a judge, you have to make a conscious effort. I still have to make that effort too. I'm including myself in this, to make the effort to get rid of those biases. I have biases against women probably. All right, and I've got to fight against that because of the way I was raised. Perhaps, I don't know. Whatever it is, that there's nothing other than the biological parts of it, like women have babies, men don't. But other than the biological necessities, there is nothing that a woman can do that a man can't do, and vice versa. So you shouldn't, if we're talking what's best for children, what is in the best interest of children, look at the social science, and then also look at the individual situation and make a decision based on that. And I'm saying that decision, all things being equal, should be approximately equal time where it can logistically work out. Now, if you've got, you can have now, and the Divorce Act and Children's Law Reform Act tell us this by the way it's structured, you can have equal time, but if these parents cannot communicate at all about decisions, well, maybe all the decisions will be made by dad, or maybe all the decisions will be made by mom, or maybe dad will make the extracurricular decisions and mom will make the healthcare and education decisions. You can divide it up any which way now. And the case law said we could do that even before the two acts were amended. But now it's specifically there. You have a parenting time order and you have a parental decision-making order, or orders in the plural. So we can adjust to the individual situation. We want to shield children from conflict, absolutely shield them from conflict. Parents should know better. They should know they cannot fight in the presence of their children. Their children are within earshot. Parents should know that they can't badmouth the other parent, the other parent's family to the child. The child is one half made up from the other parent. And so I wish parents knew better, but some don't. And you have to set guidelines, very strict guidelines sometimes for them. But the time should be, all things being equal, should be about approximately 50-50, where that is at all possible. That's my plea to your viewers. That's my plea to my colleagues, my fellow lawyers. And that's my plea to the judges. I'm consistent, if nothing else.
Yes, indeed. I want to continue this point and ask about your advocacy in support of family law reform bills and what changes you believe still need to be made. So the two that come to mind that we talked about earlier were C560 and C78. Do you want to maybe give the listeners a very brief summary of what was proposed in those bills and what your position was about them?
Sure. All right, C560 was introduced in the Canadian Parliament, the Canadian House of Commons, by a conservative backbencher, Maurice Vellacott. And it was introduced in Parliament on 6th of December 2013. Oh my goodness, that's like just shy of 8 years ago. I'll deal with that bill first, and I'll talk about C78. Bill C560, which was the second bill that Maurice introduced, advocated a rebuttable presumption for equal shared parenting. The bill laid out some of the circumstances in which there could not be equal shared parenting. And it said, all things being equal, you should have equal shared parenting, both in terms of time, in terms of decision making. I was privileged to be a part of the drafting of that bill. I don't think I was the principal drafter, but I certainly worked on the bill, along with some other lawyers and other people. And I was very committed to the bill. I wrote frequently about the bill. I advocated for the bill. I sat with my member of Parliament on more than one occasion about the bill. Made a PowerPoint presentation. The previous bill that was similar to that bill in a previous legislature, I can't remember the number, doesn't matter. But I remember then it was Ken Dryden, the former goalie for the Montreal Canadiens, was the member of Parliament for York Centre. I remember received me very nicely, and I made a PowerPoint presentation to him and talked about the social science and everything, talked my guts out. And I worked very hard, along with a large number of other people who were involved in the equal shared parenting movement. And we tried to get this bill passed. The House of Commons voted on it as second reading. Let me explain. We have 3 readings for a bill to pass. First reading is just sort of, it just gets introduced, first reading, and it goes forward. Second reading is where the real debate takes place. If it passes second reading, it goes to study of a parliamentary committee, in this case, the Justice Committee. So our goal was to get this bill before the Justice Committee so that it could be properly debated. People could give submissions. Canadian Equal Parenting Council would give submissions. I would have been a big part of that, along with other lawyers. And we just wanted, and that was our goal, just let it go to committee. All right, and if after committee you think it's not a good bill, then vote against it. So it wasn't a government bill. It was Maurice Velicott's private member's bill. Had a lot of support. Barbara Kay, columnist for the National Post, wrote a number of editorials, number of columns showing support for this bill, explaining why, talking about the social science. Barbara Kay was just fantastic. And it came up for a vote. But what happened before the vote? The Prime Minister, Stephen Harper, informed the members of Cabinet that they're to vote against the bill. Well, this is a member of his own party putting forward the bill. At that time, rebuttable presumption for equal shared parenting was a policy platform of the Conservative Party. And you can largely thank Glenn Cheriton, who is still the president of the Canadian Equal Parenting Council, for getting that through years ago. But it was the policy, the written policy of the Conservative Party. And Stephen Harper told his cabinet to vote against. Now, once he told the cabinet to vote against, then all the cabinet secretaries voted against as well. They weren't obliged to. It's not that Harper gave an order to the Conservative Party at large to vote against. He didn't. Just told the cabinet to vote against. But the cabinet secretaries voted against. This is a Conservative majority government. At second reading, it was 174 against, 80 in favor. 79 Conservative backbenchers and Elizabeth May, the then head of the Green Party, voted in favor. And I know a lot of people did a lot of work to bring Elizabeth May around as well. I don't know if it got to third reading. I don't know how she would have voted, but at least in second, she was convinced that it should go to committee. Of course, that was on 25th of March, 2014. This was a huge blow to the equal shared parenting movement. A year or two later, when my party membership came up for renewal, I did not renew. Maybe that was a childish thing on my part, probably was. But I did not renew my party membership. And just a few years ago, I had occasion to be at a conference. And who's there but former Prime Minister Stephen Harper. So we exchanged some pleasant words about that. But it was funny. We both laughed. But I expressed to him my deep disappointment as a member of the Conservative Party for many years that he gave that order.
Do you know why? Did he give you his reason why he
told
why?
I'm not going to say out on YouTube.
Okay. All right.
But he told me he couldn't remember why. But I think I know. In a private conversation, I will inform you what I think was up there. But I don't want to say it publicly. It's nothing terrible, but it's just not for me to say out publicly, because if I'm wrong, someone will get very angry. Some people will get very angry at me. I don't want people to get angry at me. But that's how it went, all right? That's how it went. And so that was my involvement in C560. Really, some of that wording, I had wordsmithed, I had switched around. I was really committed to that bill. So that brings us to Bill C-78, passed by the current Liberal government. So we haven't had any family law reform on the federal level for quite some time. And they brought forward this bill to get rid of the outdated words custody and access, as I've indicated, substituting parenting time and parental decision and parenting or parental decision making, which is positive. There are a number of blog posts that I have attached to my website, complexfamilylaw.com, where I supported many aspects of Bill C-78, and I complained about some aspects that were missing. What do you think I was missing? Well, what was missing was a rebuttable presumption for equal share parenting. What is very interesting here, of course, it passed second reading and it went to committee. And I was privileged, along with other lawyers and other law professors, to present to the Commons Committee. And I made my presentation to the Commons Committee, and I was received nicely and politely. And I was involved as one of the authors of a written submission on behalf of the Canadian Equal Parenting Council, Lawyers for Shared Parenting, um, um, various other organizations I don't recall right now that joined in the submission. So we made a written submission as well to the committee, a scholarly submission with social science literature and everything. But they did not include the rebuttable presumption. All right. Parliament is supreme. Parliament can decide what to include and what not to include. And these are our elected representatives. But here's what's really interesting. Here's the surprising thing, and I think it's going to knock people's socks off and that don't know about it. What do you think the principal debate was about with many, if not most, of the law professors and lawyers and interest groups that made presentations to the Justice Committee of the House of Commons? What do you think the issue was? Warren, what do you think it was?
I don't know. I know that money is always a central issue, but was it
Not in
around
this.
finances or was it around
No,
no,
no.
something else?
A rebuttable presumption for equal shared parenting. A rebuttable presumption of equal shared parenting was not in the first version of the bill put forward. It was not in the second reading version of the bill. It wasn't even on the table. But everyone talked about it. Everyone, certainly the submission that I, along with my colleagues, submitted, the written submission, talked about it. Certainly the presentation that I made and that other lawyers made, such as Brian Luddenberg, made a very good presentation as well, and others. Certainly we talked about rebuttable presumption of equal shared parenting. Okay, it's our issue. One would expect us to do it. One would expect the Canadian Equal Parenting Council to make such a submission. But what is the Canadian Bar Association doing talking about rebuttable presumption and why it should not be included? What were they worried about? And Canadian Bar Association, the premier organization of lawyers in Canada, what are they worried about? Why are they talking about it? Why are they making submissions, written and oral, against the rebuttable presumption?
Well, in that case, maybe it is money because they make a lot from the fees they charge to their clients, right?
People that are involved in the divorce industry make a fair amount of money, in some cases a lot of money, from conflict. And you have this group like Colman and others, Ludmer, a few other lawyers across Canada, and organizations like the Canadian Equal Parenting Council, like the Canadian Association for Equality, saying, we have a better idea. We have the social science on our side. We say, all things being equal, the parenting time should be equal. Well, what do? You remove conflict. People negotiate in the shadow of the law. If the law says rebuttable presumption for equal share parenting, chances are you're going to agree to it. What's the point of fighting the presumption? Well, in some cases you fight it because the facts are such that it should be fought. But for the most cases, then they're going to go with the 50-50. And you're going to reduce conflict. You're not going to get rid of all conflict. You're going to reduce it. You reduce conflict. Oh my goodness. Some lawyers, some mediators, some arbitrators, some custody assessors, some social workers are going to make less money. Oh well.
But it seems like it's better for society as a whole.
Yes. I was pleasantly shocked by the submissions that were made. And that tells me that history, yet to be developed, is on our side. Folks, there will be a rebuttable presumption for equal shared parenting, because those forces that are against the presumption, they know in their heart of hearts that they're doomed. If they didn't know, why did they make such a fuss before the Justice Committee just a few years ago? Why did they make that fuss? It wasn't in the bill. They had won. They had won on the in the Department of Justice who drafted the bill. Those lawyers that drafted the bill, those insiders that did the drafting, they won. They beat us. But they know the Canadian Bar Association, all those LEAF, Women's Legal Education Action Fund, all those groups, they know that history is going to be on our side, that it is going that way. There have been small inroads. Kentucky, now for a few years, they started with passing an interim presumption on an interim order before trial. Then a year later, they brought forward a presumption for the final disposition, trial or other final disposition, rebuttable presumption, Kentucky. Arkansas, just a month or two ago, about 2 months ago, I think, passed rebuttable presumption for equal shared parenting. Other jurisdictions have equal shared parenting friendly statutes. It's like it's not rebuttable presumption necessarily, but close to it. Australia had reforms many years ago that favored equal shared parenting. Anywhere you put forward a statute that gives at least some emphasis to shared parenting, shared, not even equal, but shared parenting, conflict goes down, court filings go down, more people settle on their own. Any studies show that kids are doing better in those jurisdictions overall. It's on our side. The trend is with us. I am optimistic. Not rose-colored glasses, but I'm optimistic.
Well, it's always good to be optimistic. Jean, I wanted to just touch on our final point, which is how you found the Canadian Centre for Men and Families and why you chose to donate to this organization, and also what you hope to see us accomplish in the years to come.
Well, you got to go back to the first organization, which is the Canadian Association for Equality, CAFE. It is CAFE that formed the Canadian Centre for Men and Families. I think I have the politics or the history of that correct. And I was asked early on to be on the advisory board of CAFE. So I've followed with great interest the various projects of CAFE. And of course, most important being the shelter for men and children that has been opened in the northwest corner of the city. This is groundbreaking. Earl Silverman of blessed memory in, Saskatchewan, Alberta. I think it was in Alberta. Earl Silverman formed a center for men and children using his own money, his own home, but it didn't get wide enough support. That was many years ago. But Canadian Centre for Men and Families was able to get wide support and funding for their project. And I just read on a post this morning on an email list that the advisory board gets that there's huge demand for the services of the center now. They're asking for bunk beds. They're bursting at the seams. This is a successful organization. It's not just, neither CAFE nor the CCMF are just concerned with family law. These organizations are concerned with the well-being of men and boys and families generally, whether it's healthcare, whether it's violence, no matter what the issue. If it impacts men and families, then CAFE and CCMF are there to try and deal with it. And hats off to Justin Trottier, the executive director of these organizations. He's done a fantastic job, as have the various advocates like yourself, Warren, on the West Coast. A fantastic job bringing these issues to the attention of the public, to the attention of decision makers, politicians, in a credible and balanced fashion. You know, when I was involved in forming Canadian Equal Parenting Council, that was one of the key points that I emphasized. We cannot be perceived as just a bunch of crazy men's rights advocates. It has to be balanced. It has to be sensible. It has to be non-emotional. And that's what CCMF and CAFE have done. And they've done fantastic work on campuses, bringing in guest speakers, sensitizing university students to these these gender issues. And so it's something that I believe in. And I had the wherewithal, CAFE and CCMF would be what I would have founded. Okay, I was dealing just with the legal aspect. It's what I know. And these organizations have gone beyond just the legal and taken a very holistic approach. And what are they trying to do? They're trying to make the world a better place for everyone, not just for men, not just for boys, but for women, for girls, and for everybody. So what's there not to support? So the extent that I'm able to give charity, I don't like the word charity. I go by the Hebrew word tzedakah. And the root of tzedakah is TZDK, tzedek. And it says in the Torah, in the Bible, it says justice, justice, twice, justice, justice shall you pursue. And tzedakah is justice. And I see by giving money to these organizations, it is pursuing justice. And I'm not talking justice in the narrow legal sense. I'm talking justice in terms of doing what is right and good to make this a better world. And I can't think of a better organization to give to if you are a guy or a woman or whatever, and you are concerned about where society is going, and you are especially concerned about how children are treated and what services are available for children, then this is the organization to give to. This is the organization. There's just no question. I'm not saying to give all your charity money there, but set aside a place for the Canadian Centre for Men and Families. You can go to their website and Google it. I don't know the URL off the top of my head. Go there. There's a place you can click. I'm sure there's a place to click to donate. You'll be helping a good cause, and you'll make yourself feel good too in the process. Tzedek, tzedek tirdof. Justice, justice shall you pursue. And so I've put my support on a religious level. You know, obviously I try to be a religious Jew, and for me that's the essence of life. Try and do what God expects of me, and I think I'm doing what God expects of me by supporting this organization.
That's a very good endorsement. Thank you, Gene. And so I just wanted to conclude with contact for the listeners. You mentioned our organization, Canadian Centre for Men and Families, and the link will always be in the description of the video, but it is menandfamilies.org, O-R-G, is where anyone can come to give a donation to us. If they want to reach you, do you want to share your URL?
Sure, complexfamilylaw.com.
Okay, perfect. Thank you. Well, Gene, this has been an amazing conversation. I hope it sparks some other conversations and debates and some thoughts in the minds of our listeners. And I hope we get a chance to speak again sometime.
It would be my pleasure, Warren. Thanks for inviting me.
Okay, have a nice day.